You're looking at a picture of my client, Ashley Berrier. She was 4 years old on May 7th of 2003 when she went to visit her grandparents. Her grandpop was outside mowing the lawn on his Simplicity Regent riding mower. They call them a lawn tractor. And Ashley went outside to give him a flower. And he put it in a kind of neutral, accepted the flower, said, "Thanks, Ash," and thought she had gone back inside. He then put the lawn tractor into reverse. And this was a particular kind of lawn tractor that, unlike other models made at the time, was not equipped with what's called a no mow in reverse switch. That's what happened to Ashley. Grandpop Melvin Schaff backed up over her foot, which was cleanly and neatly amputated. She received excellent medical attention, urgent medical attention, but there was no way to reattach her foot. Ashley was referred to our firm, and later in 2003, we brought what Dan and I frankly thought was, if there is a conventional one, a fairly conventional product liability suit. We thought the issue was whether or not this was a product that was safe for its intended use, and whether it came with every element necessary to make it safe for use. Turns out that the case was a little bit more complicated than that. The Berrier case, as of 2 days ago, has been cited 98 times. After we lost on summary judgment, when the federal district court judge decided that Ashley Berrier was not an intended user of the product and therefore had no claim, the case went to the Third Circuit. And the issue, we thought at the time, was, does Section 402A, the prevailing law of product liability under the second restatement, cover bystanders? That's the issue we briefed to the trial court. That's the issue we argued. We lost it, and that's the issue we argued to the Third Circuit. And when we argued the case to the Third Circuit, we filed a brief. It was 55 pages long. 1.5 pages of our brief was devoted to the third restatement. We had no thought or inkling that the Court of Appeals was even thinking of adopting a new version of product liability law. Our opponent didn't argue it either. The Third Circuit, though, had concerns about whether or not the second restatement did in fact cover bystanders. They asked the Supreme Court, they certified the question in an unusual procedure to the Pennsylvania Supreme Court and said, "Hey, do you cover bystanders under Pennsylvania law?" And the Pennsylvania court said, "We respectfully decline to answer the question." So the Third Circuit then had to make a prediction, the Berrier prediction. And the prediction that they made in 2009 was that we're not going to deal with whether or not the restatement of torts Section 402A covers bystanders, because we predict that the Supreme Court of Pennsylvania will move to an entirely new body of product liability law, the third restatement of torts, which is as different from 402A as one could imagine. We all know the case of Erie versus Tompkins. We remember it from law school. And what Erie versus Tompkins tells us is that the law that's applied in a federal court should be the same as the state court law. Berrier predicted that the Supreme Court, and of course all the intermediate and lower courts, would apply the third restatement. But in 2009, the Supreme Court didn't apply it. They continued to apply the second restatement. And they did in 2010, and they did in 2011, and they did in 2012, and they did right up to the present time. How long does a federal court hold to a prediction that didn't pan out? We are in the midst of something that is, I think, unprecedented, where if you file or get removed in your product liability lawsuit to federal court, the great likelihood is that the third restatement, a kind of negligence-based form of product liability, will apply to your case. If you file your case and stay in state court, you will certainly have the second restatement, Section 402A, apply to your case. And what got the court into trouble was this notion that they kept repeating that strict product liability law is divorced from negligence concepts. So you don't look at foreseeability. That's a negligence kind of issue. You look at whether the use was intended. What does that mean? Well, it was kind of unclear. So along comes a case called Phillips versus Cricket Lighter in 2003. And the Phillips case concerned a little boy, 2-year-old, who got a hold of his mom's lighter. Now, we know that back then and years before, lots and lots of lighters had a little child-proof feature. This cricket lighter did not have that feature. And as a result, this little boy was able to start a fire in the house, and 3 people were killed. And a product liability suit was brought against Cricket saying, you didn't make this product with everything necessary to make it safe. And as a result, people were hurt and killed. And the Supreme Court of Pennsylvania says, well, but we are divorcing negligence concepts from strict liability concepts. And while this child may have been a foreseeable user of the product, we're not concerned about that in strict liability. He was not an intended user. So no strict liability claim for anyone. It's against that backdrop comes the barrier case, Ashley. Intended use by an intended user always resulted in the application of Section 402A in Pennsylvania and everywhere else in the country. And in barrier, we had an intended use, using a lawn tractor to mow the lawn, by an intended user, an adult operator. The problem was, the Third Circuit said, whether or not Pennsylvania had expressly decided to cover bystanders like Ashley. So the Third Circuit did something unusual. They said, you know what? We're not going to deal with that issue. We're going to predict that the third restatement is adopted as the law of Pennsylvania. And that was a very dramatic decision.